let's start. In our view, at the present stage and on prima facie consideration of the matter, the only logical approach would be to proceed on the basis of the version of the SI as given in the written complaint, because it is not the case of the appellant that the version in the written complaint is not correct. In this view of the matter, the very edifice of the prosecution case against the respondent crumbles down and falls flat, putting it differently. The story of planting of contraband in the vehicle in question by some third person like Amritraj Singh could only be disbelieved for being squarely contrary to the initial case of the prosecution as stated in the written complaint. Once the veracity of prosecution case against the respondent is in serious doubt, further analysis on the other factors about financing the drug trafficking and harboring of offender need not be undertaken, because when the story of planting of contraband is removed out of consideration, all other factors by which respondent is sought to be connected with such alleged planting could only be regarded as false and fanciful, at least at this stage. Hence, suffice it to observe for the present purpose that in the given set of facts and circumstances, the High Court has rightly found that the applicability of Section 27A NDPS Act is seriously questionable in this case, that being the position and there being otherwise no recovery from the respondent and the quantity in question being also intermediate quantity, the rigors of Section 37 NDPS Act do not apply to the present case. After the discussion aforesaid, we are constrained to reiterate that the High Court has dealt with this part of the matter without much elaboration, and rightly so, for only the prayer of bail being under consideration. However, we have considered it appropriate to delve further in the matter in view of the submissions made and material presented before us. In any case, for what has been discussed herein above, the result precisely remains the same as indicated by the High Court, that diametrically opposite case in the charge sheet than that alleged in FIR gives rise to serious doubt on the veracity of the prosecution case against the respondent. In this view of the matter, the other part of submissions and reference to the cases of MD Nawaz Khan and Riya Chakraborty within bracket Supra do not require much elaboration. As aforesaid, when the case against the respondent of getting the contraband planted in the vehicle in question is prima facie disbelieved because of material available on record, the questions concerning possession of contraband, its quantity or financing are all rendered redundant in this view of the matter. Reference to the other pieces of supporting evidence like the alleged statements of the said MD Nasir Khan and Nishat Alam at the rate of Ruman Khan, as also the alleged CCTV footage and call data records, cannot provide sustenance to the prosecution case against the respondent, at least at this stage. Thank you.